SJC-11110, Commonwealth versus Jordan.
All right, let's proceed.
Morning, may it please the court. John Zanini for the Commonwealth. The Commonwealth is before the court asking this court to vacate the judgment of the single justice in the county court denying the 211-3 petition and to enter a new judgment allowing the petition, vacating the order in the Superior Court compelling the requested discovery and denying the defendant's motion. As the court is probably well aware, the only portion of Judge McDonald's order which is at issue is an order to the Commonwealth to inquire of the victim of the shooting in this case, whether he was at some point in time for some agency an informant for the Commonwealth. And the written portion of the order is in the Commonwealth's appendix at 33 in Judge McDonald's handwriting. Under the Commonwealth v. Beale case, I would suggest that the order to the Commonwealth to make a specific inquiry of a victim, in this case, whether he was an informant at some other time for some other agency, is beyond the authority of the court under Rule 14. And in addition to being beyond the authority under Rule 14, there's also a privilege for an informant, which is long recognized by this court. And this order improperly pierces that privilege. And the most recent case, I think probably on that privilege, is the Madigan case, in which that's in the briefs. It's at 449 Mass 702. In Madigan, there was a piercing of the privilege on an entrapment theory, and the factual basis for the entrapment theory was set forth in the defendant's personal affidavit. As I read the case, the defendant personally filed an affidavit setting forth the facts that underlay his defense. Unlike this case, in this case, there is no affidavit filed by the defendant setting forth any facts. And most of the facts in the attorney's affidavit, which is in Commonwealth's Record Appendix 27, many of these facts either simply recite the grand jury testimony of the victim, Mr. Sanchez, or discuss some after the post-shooting inquiries by the attorney into Mr. Sanchez's record, his Board of Probation record. There is nothing in here about the defendant's state of mind at the time of shooting or the defendant's knowledge at the time of the shooting, except in paragraph 8, where there is a statement that the defendant believes, this is on Record Appendix 29, the defendant believes that the reason for the null pros and the fact that Sanchez was debriefed by the police, which sort of comes out of nowhere, is that it appears likely he cooperated with a state or federal investigation. So the only assertion about the defendant's state of mind that I see in this affidavit is his attorney's assertion about what he believes.
Somewhere is the, and I'm not sure it's in the affidavit, but somewhere is the allegation that the defendant wasn't going to report the threats that Mr. Sanchez had made to him because he thought the defendant, the victim, was a protected player.
Yes, in Commonwealth's Record Appendix, page 24, in the motion for disclosure of informant status, in the middle of the page, there's a paragraph that starts here, Sanchez's status is relevant as an informant to the shooting. The third sentence says, the defendant's actions and reactions were based on his belief that as an informant, Sanchez would be protected by the police should the defendant try to report the threats made against him.
So your point is, in any event, even if that had any bearing on this, it's not in any, but there's no affidavit from the defendant, and it's not even in Mr. Masferrer's affidavit.
I believe that's correct. There's nothing about failing to report threats that I saw in the affidavit. It also says, and this is important here, he says that his status as an informant serves to corroborate the state of mind, which it can't because he doesn't know about this privileged secret status, if it exists, which we asked the police officers on the case. They said they don't know about it.
But he thinks it's true, right?
But that's all he needs to say then. Assuming that his defense is admissible, he needs to say, I think this was true. But he can't corroborate his defense with something he doesn't know when it's his state of mind that's at issue in his defense. And he says, in this motion, he says this is the heart of his defense. Self-defense is the heart of his defense. He says that again in his brief. The problem is, if your theory is self-defense, that's the heart of his defense. The facts as set forth in the Commonwealth statement of the case before the motion judge filed in the Superior Court, even the facts recited in his affidavit of the testimony, nowhere is there any establishment of any fact that could possibly raise a self-defense claim. Mr. Sanchez knocked on the door of Mr. Jordan's house, his cousin, his younger cousin, in order to try to collect on a debt. Mr. Jordan opened the door and shot him twice while he's facing him. He turned to run. He shot him twice more. He fell to the ground. He shot him 3 more times. I mean, you know, I cite the Harrington case in my reply brief. Self-defense is just not an issue in this case. There is no factual foundation in the grand jury minutes, in the statement of the case, in this affidavit, and there's no affidavit from the defendant to establish a self-defense case.
Was there any evidence in the record that the victim had been armed?
No. In fact, the only reference to the victim potentially being armed, I believe, the defense counsel's affidavit makes reference to family members of the defendant telling the police, we think there might be a gun in the car, in the victim's car. The car belongs to the victim's brother or cousin, I think. There's no gun in the car. There's no weapon at the scene. There's no way to raise a self-defense.
There's no weapon on
this
him when
case.
he's shot.
Excuse me?
He's shot and falls, right?
Yes.
There's no weapon on him.
There's no weapon recovered at the scene. He didn't have, there was no fact that there was some other accomplice, someone who might have run away with a gun or hidden a gun. So, unless the court has other questions, I would be prepared to rest on the brief.
Thank you.
Thank you.
Yes, counsel.
Thank you, Your Honor. And may it please the Court, Eduardo Masfer for the appellee, Jesse Jordan. First, as a preliminary matter, the Commonwealth hasn't demonstrated what this Court ordered it to do, that in order to reverse the finding of the single justice who denied their initial appeal, the Commonwealth must demonstrate a substantial claim of irremediable error and exceptional circumstances where it is necessary to protect a substantive right. Here, we're talking about a routine discovery motion and ruling made by judges that the trial court makes.
Hardly routine.
When the defendant makes an affidavit saying there is relevant evidence, and the relevant evidence was limited to corroboration as to whether or not Mr. Sanchez is an informant.
You think it's routine to ask victims of crimes whether they're informants for police
I think
without an affidavit from the defendant suggesting something that relates to it?
I think it's routine for a trial judge to make a relevancy determination, which is what we're talking about here, regarding whether or not a particular agent of the Commonwealth is in fact the agent for the Commonwealth. The Commonwealth keeps couching Mr. Sanchez as a victim. He's an agent. He's an informant who's been working with the Commonwealth.
How is that relevant to this case?
It's relevant because when Mr. Jordan receives, and this is what is detailed in the affidavit, Mr. Jordan first receives a phone call from Mr. Sanchez.
Which is your affidavit?
Yes, Your Honor, and cited in the grand jury minutes as well. Mr. Sanchez is outside the police station calling Mr. Jordan saying, I'm coming over, you better pay my debt or your family's going to hate me. The implication of your family's going to hate me is that I'm going to come over and kill you and the rest of your family is going to hate me for killing you. Mr. Jordan, knowing this individual's prior history, then doesn't invite him over to his house. Rather, he comes to his house. What happens at the doorway of Mr. Jordan's home is in dispute. It's all factual issues that are in dispute. The Commonwealth provides no affidavit or grand jury minutes or any record to support its allegations that Mr. Jordan fired from him from inside his house and that Mr. Sanchez turned to ran away and that's why he got shot in the back. We dispute all of those facts.
Well, did Mr. Sanchez so testify before the grand jury?
He testified to parts of that before the grand jury, yes, but then it's his credibility that's issue as to whether or
Well, you
not
say
that's
there's
what
no
occurred.
evidence.
In terms of what was provided to the court, to Judge McDonald to make its decision, or to the single justice to make its ruling as to whether or not the relevancy determination that had to be made was sufficient. And that's what we're talking about. Was it relevant to order the Commonwealth to make one specific inquiry, simply corroborate whether or not he's an informant?
Okay, well, let's take it step by step. You agree that the order of the judge was improper under Beale.
No.
How could it not be?
Because Beale
How
deals with-
under Beale can a judge order the Commonwealth to ask a witness a question and then report the answer to the defendant?
Because under Beale, we dealt with a civilian witness who had no connection to the Commonwealth. And under exculpatory evidence, under the rules of exculpatory evidence, the defense made a request to require the Commonwealth to make an inquiry of somebody who's not related to the Commonwealth. That's not this case. Here you have an agent of the Commonwealth. The information is in their custody and possession and control. And the Commonwealth asserted during the hearing, and this is the factual record that we have. The Commonwealth, even though this Suffolk County District Attorney's Office null-prossed a 2008 drug trafficking case. When they did that, the Commonwealth then stated, we have no information, we don't know, but the victim, Mr. Sanchez, is here, and so the court says, well, if you're claiming you don't know if he's your own agent or not, then ask him if he's your agent or not. It's not everything that he's done. It's not, tell me about the details of your investigation that might be privileged or confidential. It's confirmation of what Mr.
No, it was
Jordan
much
doesn't
broader
know.
than that. As I understand it, it's any state or federal
It
agent
was.
of anybody.
It was, because that's the question for Mr. Jordan. The Commonwealth would have that information. Our position has always been that the Commonwealth has the information. The Commonwealth claims it doesn't.
Well, the
and
Commonwealth, I take it, an officer of the court has represented that the officers don't know whether this man is an agent, right? They did that part of the order.
They asked initially the lead detective on this case.
Well, I understood from the brief they asked more than the lead detective.
And then the other officers in this case, they subsequently asked the officers involved in this case. They made no effort to ask the officers who debriefed Mr. Sanchez in the case that was null-prossed. And then we wrote them a letter saying, have you looked into your own file? Don't go anywhere else. Have you looked into the Suffolk County District Attorney's Office file for a 2008 case? Here's the docket number. Here's your null-pross, where you claimed he was being prosecuted in another jurisdiction, and yet there's no other jurisdiction that's prosecuted Mr. Sanchez. So where the Commonwealth is claiming, notwithstanding that evidence, and notwithstanding their, and I'll use this term, willful blindness to not look into their own files, then the remedy becomes ask Mr. Sanchez. Beale specifically excluded in the last footnote that if the Commonwealth were to engage in willful blindness, not look into a known issue, then that would be something different.
But the judge has made no finding that the Commonwealth acted in bad faith in what they did.
Instead, the judge's remedy was ask Mr. Sanchez.
Right.
That became the limited remedy. We're not going to go, if you're telling us that we don't have the information and they haven't looked in their own files, then fine. Here's the limited issue. Ask Mr. Sanchez to confirm. That's it, whether or not he's an informant.
But the judge didn't ask them to look in their own files, did he?
They claimed at the initial hearing that they had no knowledge. And it was left at that. Even though the affidavit I provided indicated that they had what would perceive to be information in their files, they, as officers of the court, stated they had no information, and so the remedy fashioned by the court was ask Mr. Sanchez.
So under Beale, if the defendant asks the Commonwealth if they have exculpatory information regarding statements by a sexual assault victim, and the Commonwealth says we know of no such thing, if the judge says, well, I'm not sure that that's correct, so I'm going to order them to ask the victim, that's okay under Beale?
No, because in Beale, and in a sexual assault case as the one Your Honor is describing, it's a civilian witness who's not an agent of the Commonwealth.
Well, isn't that sort of the issue? We don't know whether or not the person is an agent of the Commonwealth. You're just saying that they are.
The defense is that he is the agent of the Commonwealth. Mr. Jordan, at his trial, could testify and would testify. I believed him to be an agent.
Okay, so
the Commonwealth, I'm sorry to interrupt.
No, go ahead. Please finish.
Just that the Commonwealth then, on cross-examination of Mr. Jordan, as it could argue to the jury, there's no evidence that he really is an informant. His reasonableness of Mr. Jordan's state of mind in believing that is unreasonable. It's made up. It's fiction. He isn't an informant. There's been no proof of that. Without corroboration of some sort, and the only evidence of that is contained by the Commonwealth, they get to attack Mr. Jordan for the reasonableness of his own defense and his own state of mind when the information is either possessed by them or possessed by their agent, and their agent being Mr. Sanchez. That's what makes it different than Beale, where the civilian there is not their agent. The Commonwealth is not required to do anything. And in Beale, again, it was a seeking of exculpatory evidence. We're not asking the Commonwealth to do our job. We're not asking the Commonwealth to find exculpatory evidence for us. We're saying, you have an agent. He's your agent. Confirm that for us. He is your agent, and
The
that's it.
Commonwealth argues that you should have come forward with an affidavit to explain how something you don't know can corroborate something that you argue was believed.
I think the Commonwealth has argued that they would like Mr. Jordan to sign an affidavit revealing his full defense before trial. Mr. Jordan's under no requirement to explain the details of his defense. It is ample from my affidavit and from the motion, and certainly Judge McDonald and certainly the single justice all understood that the relevance of whether or not he's an informant goes to Mr. Jordan's state of mind. And when he is asserting a self-defense claim that he felt he had no opportunity but to shoot Mr. Sanchez, when Mr. Sanchez comes to Mr. Jordan's own home uninvited and doesn't call the police or seek help, his belief is that I can't because he's going to be protected by the police. That's what Mr. Jordan felt or believes. That's clear from the paperwork. I don't think Mr. Jordan is required, and Rule 14 hasn't said that he's required to show that in his own affidavit.
What's different in this case from Madigan?
The difference here is that we don't have the sort of safety and concern issues regarding an informant in a drug case in terms of when we're talking about the entrapment defense, or that somehow if we reveal to the defendant that the informant is who the informant is or what his role is, that will cause harm to the informant, that then the defendant could then do something to him. We don't have that concern here because Mr. Jordan has apparently shot Mr. Sanchez. So there's already animosity there. There's already an issue. We're not seeking, Mr. Jordan isn't going to do anything worse to Mr. Sanchez because he now gets confirmation.
Any difference? It's a factual difference that Madigan, it's only because he wasn't endangered that the court required an affidavit from him?
It's not the only difference, but the difference between here and there is that it is clear what the defense is and how the defense would play out based on counsel's affidavit, though you don't need a more detailed affidavit from the defendant. Once we raise the self-defense claim, it is the Commonwealth's burden to disprove it beyond a reasonable doubt.
That's if you put evidence in at trial.
Yes, and we have stated through Mr. Jordan's belief what that would be. We have cited not simply a wild belief of his, rather we detailed out a series of factual scenarios both found in the grand jury minutes and found on our own investigation of Mr. Sanchez.
The defendant doesn't say he knew any of these things at the time.
He says the defendant believed that he was an informant.
You said the defendant believed he was.
That's correct, Your Honor.
All right, the
I
defendant
apologize,
doesn't
yes.
say that.
The defendant does not state that.
Are you suggesting that whenever there is a self-defense case, without an affidavit from the defendant, the counsel can simply request that the Commonwealth ask the victim whether they were an agent, because that might be relevant to the state of mind of the defendant?
I think that in any case where the defense counsel has demonstrated relevant evidence that's in the possession of the Commonwealth, that the Commonwealth can be required to ask their agent a question. Not a civilian witness, but their agent. There is no requirement under Rule 14 that the defendant sign every affidavit for a discovery motion, which is what this is. The defendant may not appreciate the laws surrounding the rules of discovery.
But this is the disclosure of a confidential informant, potentially. I mean, we don't know, but that's the essence of what you're saying. We want to know whether this person is a confidential informant. That's a slightly different question than your ordinary discovery question.
It is, but its only relevance in terms of how it plays out at trial, its only relevance is an evidentiary run. It's a legal one. If the answer
It has
is
nothing to do with the dangers that go along with the disclosure. I mean, nothing to do with why confidential informants are protected, because of the flow of information. And if they can simply be disclosed because defense counsel has some theory, then that puts all of that system in jeopardy.
It doesn't, because of the unique facts of this case. It's not like a regular drug case where somehow I need to know I need to know who the
It might
informant
be a
is.
regular drug case, but it raises the same kind of issue.
It does, but
Even more removed from what one would ordinarily think would be relevant or material.
It does, but the privilege regarding informant status has to give way to a defendant and his right to prepare a defense. And that's what this goes to. His ability to prepare his self-defense claim, whether or not he's going to be believed or not, whether or not Mr. Sanchez is an informant is a crucial issue. If the defendant asserts it and then presents what information we have, our next logical question would be to ask Mr. Sanchez on the stand, so have you worked as an informant in some way, shape, or form? And presuming that the trial judge would allow us to ask that question, I need to know if his answer is truthful. If he says no, and a Commonwealth knows that to be false, that would be unfair to the defendant, and that would be unfair to his defense.
That would be a major problem for the Commonwealth, too.
But so now in the middle of trial, we have to now have a whole new discussion because Mr. Sanchez committed perjury, and they know that. Or the Commonwealth would then simply continue with an assertion that, well, we don't know what his status is, continue to play an issue of willful blindness. We haven't asked him. We're not going to ask him. We don't know. And the defense hasn't shown you that he is. So again, our defense is prejudiced by information contained by their own agent. If he is not an informant, then certainly that ends all these issues, and we wouldn't necessarily need to be here. But if he is an agent of the Commonwealth, and the trial has been stated,
Is or was at some point, in some case, someplace.
and we're not asking the details of that some case, someplace, and so therefore any issues regarding the jeopardizing of investigations or the safety of Mr. Sanchez in some other case is not raised by this issue, and the Commonwealth could seek protective orders, limiting disclosure of the information, limiting the way in which it's used at trial, or sequestering people who are in the Venari during the trial to prevent and protect Mr. Sanchez if that's the situation. But we are not there yet. That would be all trial issues and remedies available to them. For them to simply say, no, we cannot ask our own agent any questions, and therefore keep the information that only they possess within their possession and their agent's possession, that harms Mr. Jordan's
But they've already said that he's not their agent. And so, I mean, it's one thing to have as the remedy. Perhaps they can be made to do a more comprehensive inquiry as to whether he's an agent. But if they say he's not an agent, then how can you use his agency as the justification for this inquiry?
They actually haven't said, I don't believe, that he is not their agent. They've simply said that under Beale, they shouldn't be required to ask the victim of the crime.
They asked the officers who said that he isn't.
But that's the officers of this particular shooting case. Those particular officers wouldn't have any information.
So if he's working in an unrelated federal investigation, he should be viewed as their agent?
If the Commonwealth has information and they're the ones who provided him to the federal authorities, then yes. My biggest proof that they know is, again, that Dorchester case, that Suffolk County case where he was debriefed. That's what I cited to in my...
Your view is that a witness is an agent of the Commonwealth with regard to a particular case if the individual ever was a confidential informant for any government criminal agency.
Not any government agency. It has to be related somehow back to the Commonwealth in this case. A federal law enforcement officer is not related to the Commonwealth. They haven't stated that.
So if he's an informant in Worcester, that still makes him an agent of this particular, with regard to this particular matter?
No, Your Honor. When he was debriefed by the Boston police, if the Boston police coordinated with the federal authorities and then had him go work with the federal authorities, then yes, that's a joint investigation. They knew what was going on. It's it's information in the Commonwealth's possession, and he is an agent of the Commonwealth in that case. There are a variety of circumstances whereby somebody who is a victim of a crime is still an agent of the Commonwealth. And they and the officers involved in that investigation don't necessarily participate in other issues. For example, if a police officer is harmed or shot or hurt in an assault and battery on a police officer, they don't then participate in their own investigation. They don't participate in their own case. But their status as a police officer certainly is not known by the Commonwealth, and there might be something relevant because of their status as a police officer that might be within the Commonwealth's possession that the Commonwealth can be required to obtain. Differentiating from somebody who's a rape victim who has nothing to do with the Commonwealth in that matter.
Counsel, I'm afraid we're going to have to leave
Yes, Your
it
Honor.
here. Thank you very much.
Thank you, Your
We'll
Honor.
take a brief recess.